Hello, everyone. My name is Ariella Wagner. I am the founder of SunRay Construction Solutions. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights with our incredible online application. Today, we have a fabulous webinar conducted by the incredible board-certified attorney, Alex Barthet. And the topic today is 3 contract terms that should not be in your next contract. So without further ado, I introduce the fabulous Alex Barthet.
Thank you, Ariella. As Ariella said, my name is Alex Barthet. I am a board-certified construction attorney here in the state of Florida. And today we're going to talk about the 3 contract terms that should not be in your next contract. So let's get right into it. So on today's agenda, we're going to talk first about why your contract matters. And then we're going to talk about the 3 specific items that shouldn't be in your contract. One is not having the right to stop work. 2 is a very short and effectively no opportunity to cure provision. And 3 is an obligation to accelerate your work without compensation. At the end, we'll take any questions you have. And as to those questions, do remember that the way you submit them is through the GoToWebinar chat box should be on the right-hand side of your screen. Go ahead and submit them and we'll answer all the questions at the end, but please do not include any names of people or companies in your question. All right, so let's first explain why your contract matters. It is the rule book. It is where everyone is going to go when there is a dispute about how to handle a change order, what to do if there's a conflict in the field, how to deal with schedule issues. All of those things should be in your contract. And if you have a written agreement, usually all of those terms and conditions and the details are ignored, except when there's a dispute. And when there's a dispute, someone's gonna open a drawer, take out the contract, and they're gonna start pointing to provisions outlining who has what obligation to whom. And that rule book, this contract, is gonna become very important when there is a dispute. Now, in the worst case scenario, if this dispute were to escalate all the way into a legal dispute where people are suing each other, just know that the court, the judge, the jury is almost always going to use the contract as the controlling rule and outcome of the dispute. So if we have to go to court and the contract says that all change orders have to be in writing, and you want to argue that there's a change order that's not in writing and therefore even though it doesn't comply with the contract, it should be paid, that's going to be an uphill battle because the judge and the jury is going to like to just apply the simple rules that the parties agreed to in writing in their contract. So remember, this contract is going to become very, very important and is very important if there is ever a dispute. So let's talk about the first of 3 provisions that in my 20 years of experience, I would tell you is probably one of the most dangerous provisions in a contract. Now, most of the provisions that I'm going to show you, or I should say all of the provisions I'm going to show you, are from the perspective of the subcontractor, meaning these are typical subcontract provisions. But just know that I've seen provisions like this between owners and contractors and between subcontractors and subcontractors. So it doesn't really matter where you are on the chain of contracts. The issue is what matters most. So people ask me, clients ask me, they say, Alex, look, I've got this 10, 15, 20 page contract. I really want to do the work. You know, tell me what are the top 2 or 3 items that are the things that you would change. And that's really what this presentation is premised on. And by far, the number 1 item I would change is this one, not having the right to stop work if you're not getting paid. So here is a sample provision of what it looks like. I've seen them in many different forms, but this is a good example. Subcontractor shall diligently proceed with the work during any dispute, even as it relates to payment or changes. The existence of a dispute shall not be the grounds for any failure to perform by subcontractor. So what does this mean? This means that if you're not getting paid on the construction project, if they're not approving your change orders, you have to follow the dispute resolution process that's in the agreement, which typically is something like a meeting of the principals, and then if that doesn't work, maybe a mediation, and if that doesn't work, either arbitration, which is like a private court, or litigation, which is the court that you see on TV. The problem with that is that it takes time to get to the finish line. And in the process of doing all of that, you have to do what? You have to keep working. You have to keep paying your employees. You have to keep paying your suppliers and delivering material. It can really drain your the cash flow in your business, because as you are fighting a fight, and you may have to have a lawyer involved, so you're paying a lawyer, you're still prosecuting the work. Because if you fail to prosecute the work, meaning saying, well, if you're not paying me, I'm just going to walk off the job. If you have a provision like this, you technically do not have that right. So how do you deal with it? So here is a sample provision that you would put in your agreement, meaning as you negotiate your agreement, you would identify the obligation to keep working, and you would strike it and add something like this. Subcontractor can slow or stop work without liability or penalty if it has not been paid its draw request in 30 days after submission. Now, let me pause here and tell you that it's not so easy to get the counterparty to your contract to agree to the changes you want to make. What I can tell you after doing this for a long time is that owners will make more changes than you think, but won't make any changes unless you ask. The same is true for contractors. All contractors will tell their subcontractors, we don't make changes to the agreement. I am here to tell you that for every trade, on every job, they are in fact making changes. Some changes more than others based on relationships, based on the importance of that sub, whether or not they can get another price from someone to do that work so that they can still fit within their budget, availability of men and material. So all of those things go into how much leverage you may have, but don't believe their position or their statement when they say, we don't make any changes to our contract. If you don't ask, you won't get. So as to this specific provision, I will tell you that they probably will not agree to 30 days. So maybe it's 45, maybe it's 60, maybe it's 75. What's important is that it's not never. There is some point at which, if you are no longer being paid, you have the right to stop work. It is generally a pretty reasonable position to take, right? I mean, if you're negotiating with the other side, you're going to tell them, look, this is pretty straightforward. I have bills, I have employees, I have insurance, I have overhead, I have materials I have to buy. If you don't pay me, I cannot keep working. I cannot finance this job. So I need to know that after a certain amount of time, if I'm not being paid, I can stop work. Most people on the other side will tell you, yes, that's reasonable. Let's see how we can negotiate these terms. That being said, I negotiated $1 million appliance package for a supplier recently, and the contractor in the owner's position actually was, yes, that's a very reasonable position, but we refuse to accept it. Under no circumstances can you stop working, even if you're not being paid. So the client at that point had to make a business decision on whether or not they were going to continue with the contract. They ultimately decided to continue with the contract and accept that risk. What's important though is that they did it clearly with their eyes wide open. They understood that that's a risk that they're going to take. Make sure that you try to include a right to stop work if you are not being paid. Number two, very short notice and no meaningful opportunity to cure. Also, I would say on the top three of the problematic provisions in your contract. So here is a provision so you understand what it looks like. Should subcontractor violate a provision of this agreement or at any time refuse or neglect to supply a sufficient number of skilled workmen or neglect to supply materials of the proper quality or fail in any respect to prosecute the work with promptness and diligence, or fail to repair or remediate defective work or materials, or fail in the performance of any of the representations, warranties, or agreements herein contained, contractor shall be entitled to, upon 1 calendar day written notice to subcontractor, to provide such proper and suitable labor and materials and to deduct the cost thereof from any money then due or that may thereafter become due to subcontractor under this agreement, or at the election of the contractor, terminate the employment of the subcontractor. So what does this mean? This means that if you have a provision like this in your contract, and by the way, this is a pretty standard provision in most sophisticated owner contracts, as well as subcontracts with larger subcontractors, contractors. This says if you do anything wrong within 1 day, 1 calendar day written notice, the contractor can step in, deduct amounts due to you, and possibly even terminate you. 1 calendar day, think about that. That means on a Friday afternoon, when you've got a plan to go out of town, it's a long weekend, you get a written notice at 4:30 in the afternoon, and now you have 1 calendar day. So effectively, the rest of the day, Friday and Saturday, to remedy the situation. It is unreasonable. So how do you deal with this? Obviously, you need to know that that obligation exists in your contract. You need to try to remove it. And here is a provision that you can use to counter that. Contractor shall provide subcontractor 10 calendar days detailed written notice to cure any performance issue or delay or claim, or before any payments are delayed or held back or any amounts are chargeable to subcontractor. What does this mean? This means that if the contractor wants to issue a back charge, they need to send you written detailed notice 10 calendar days before they do it. If they want to supplement your forces, same thing. What does this do? This gives you an opportunity, meaningful opportunity, to cure the defect before you get back charged, before you get supplemented, before any payments are withheld. Again, it doesn't mean that they won't ultimately have the right to do it, but now you actually have an opportunity to fix the problem rather than giving the contractor effectively a gotcha to terminate you or to back charge you. And number 3, acceleration. So here's a provision that we find in many subcontracts. Subcontractor shall accelerate, decelerate, stop, demobilize, and remobilize its men and materials, and the men and materials under its control to maintain the project schedule as amended by the owner prime contractor, or contractor, all of which shall be included in the agreement price. So that means that you've bid this project, you have a method in which you're going to attack the work. Maybe you're going to start on the first floor and move up, and then there's going to be a pause, and then you're going to remobilize later after certain work is done, and you've got it all figured out. The contractor comes in and tells you, no, that's not what we're going to do. I need you to split up your crews into 4 parts. I need you some to work here, some to work here, and then I need you to demobilize all of your material and then and equipment, and then remobilize 3 times on this project. Well, if that's not the way you bid the job, now this project has become much more expensive to handle. And if you have a provision like this in your contract, that means that any understanding that you have about how you want to attack the work can go out the window at the discretion of the contractor, and you cannot ask for more money. That can be a big problem. So what does a provision look like that would change that? Any and all changes to in the schedule or delays caused by those other than subcontractors shall be the subject of a change order entitling subcontractor to additional time and compensation. Again, it's not that every version of these provisions that I'm showing you will be accepted. The intent of this presentation is for you to identify the issue, recognize that if you do nothing, the most onerous and stringent provision is going to be held against you. So you need to identify it, discuss it with the counterparty, whether that's the owner or the contractor or the subcontractor, and try to come to a resolution on how to deal with it. And I have a bonus for you because I see this sometimes as well. Another big mistake is not getting it in writing. All agreements ideally should be in writing. This includes, by the way, all of the terms, assumptions, and exceptions, because if they're not in the agreement that you sign, they don't exist. Also of significance, if it was in your proposal, but your proposal or quote or bid didn't make it into the actual fully executed contract, it doesn't exist either. So you can't say, well, when I submitted my bid, I had a whole list of exceptions. So they knew that that was part of my price. But when I look at your contract, none of those exceptions made it into your contract. Well, guess what? Then none of those exceptions are part of your contract, and you're going to have to live with the contract terms that you actually signed. So if there are a list of issues, assumptions, exclusions that are critical for your contract, are the basis of why and how you bid what you did, you need to identify those and make them part of the actual written agreement that's signed by the parties. We find that having a writing goes a long way at avoiding convenient memories. I never agreed to that position that the other side takes almost always goes away when your written agreement properly states what the parties agreed to. Know that your estimate, your bid, your quote, your proposal, those are all contracts. So get them signed, but make sure that you have terms and conditions in them that are important and critical to you. I'll end with a brief story. We represent an electrician. That electrician submitted a bid for about $500,000 on a renovation of a restaurant. Our client was the sub, has a contract with the GC. He submitted a bid. It had terms and conditions, and he prosecuted about 2/3 of the work before the contractor came back and said, okay, well, we need you. You haven't signed our contract yet. So we need you to sign it. And he says, well, I don't agree to the terms of your contract. I've already redlined it. I've made changes. You're not accepting my changes. I'm not accepting yours. You've already signed my proposal, which has its own terms and conditions. You've paid me for much of the work I've done. I am not signing your contract. And they refused to allow him to continue to work if he didn't sign their contract. And he came to us and said, what should we do? And we told him, unless you agree to their terms, you should not sign their contract. And he says, I don't agree to their terms. So our advice to him was, let them terminate you, because that termination will be improper. You have good and favorable terms and conditions in your contract, in your proposal that they signed. You have lien and bond rights for the work you've done so far. And that is my last comment, which is sometimes no agreement is better than a one-sided agreement. So don't feel compelled to always sign the agreement that's given to you, because if you don't agree to their terms, you shouldn't sign it. And know that if you do sign it, you will have to live by all of those terms and conditions. So Ariella, do we have any questions from anyone so far?
So far, we don't have any questions. But you know, a question I think that does come up very frequently from our customers is, you know, some people are so afraid to have a contract in place. They're concerned they'll lose the job. So what do you tell subcontractors or suppliers? What do you express to them as an attorney about having a contract in place?
It is probably the single best thing you can do to mitigate risk is to have an agreement in place that properly reflects your understanding of the deal. Now, again, I hear all the time from our clients that the contractor has told them that under no circumstances will they make any changes, but almost always when we push back a little bit, they will make some changes to the agreement. You know, it's not great. You know, sometimes we give our clients a 2, 3, 4, 5-page addendum modifying the agreement, and all they get changed when they finally finish their negotiations with the contractor is 15 changes out of 100. Well, those are 15 changes that you didn't have before that may become very important as the project continues. So absolutely spend as much time trying to get a good deal and negotiating your contract as you did to put that bid together, because it's just as important. Let me remind everyone about our upcoming webinars. We do these every month. Next month on June 23rd, we're going to talk about bad checks and credit card chargebacks and how to deal with them. And then in July, we'll talk about releases. And the title is "Don't Sign a Release Unless it says this one thing." And we're going to talk about what that one thing is so that you can better protect yourself. You can sign up for all of these webinars for the rest of the year at sunraynotice.com/webinars. If you go there as well, you can watch all of the prior webinars that we've done. So if you have any questions, send us an email. You can send Ariella or me an email at any time. Our email address is on the screen now. Anything else, Ariella?
You know what, Alex? Another question that customers ask is, how much would, if they reach out to you and your law firm to put together a basic contract for their business, so they have that up and running, approximately how much, sorry to put you on the spot, but just so everyone knows, they can reach out to Alex or one of his associates. How much would something like that generally be?
Yeah, it depends on what the client is looking for, but generally it's between $750 for something pretty simple to, as much as $2,000 for a complete package of documents that cover lots of different scenarios. So generally, it's very inexpensive. We provide everything in Word format, so you can edit it, put your logo on it, and they will be with you. These contract provisions, whether it's just a simple terms and conditions for your proposal or something much more comprehensive, they will be with you and serve you well for many years to come, if not even a decade. So feel free to call if
That's
you
great,
just want
Alex.
to talk about what options you have.
Sorry, absolutely. I think yeah, if anyone is interested, I think that it's absolutely essential to put together a contract. And if it's anywhere between $700 and $2,000, and not only do you secure your lien and bond claim rights, you also having that ammunition of a contract, it could save your it could save from having a massive headache. So yeah. Well, thank you,
Absolutely.
Alex. Thank you so much.
You're very welcome.
Well, I hope everyone has a sunny day.
Bye, Ariella. Bye, everybody.
Bye-bye.